All right. Once again, good afternoon. Thank you all for joining us. There are quite a number of you online, which is great to see. Thanks for making the time. Welcome to our talk on cybersecurity and privacy risk in a remote work environment. Just want to do a little bit of housekeeping at the beginning. As you'll see at the bottom of your screen, I believe, there's a tab called Q&A. So if you have questions as we go through the session, feel free to type them in there. You don't need to save them to the end. And this box will save the questions. And I think we're going to take questions at the end of our discussion, and they'll be there waiting for us. If you do ask a question in the Q&A, other participants will see your login name, I believe. So if there's a question you wouldn't be comfortable raising your hand and asking in a live seminar, probably it's best that you contact us offline. You can upvote a question if you see one that looks that you'd really like to see answered by clicking, I believe it's a thumbs up. And at the end, we'll have a sense of sort of where people's priorities are for that. There's also some survey questions you click the poll tab for those, but I think that they will be going up sort of throughout the talk. These are sort of, your answers to those will not be obvious to your fellow participants. So you can go ahead and answer those without fear that people around you will know your answers. And they will perhaps give you a bit of a sort of a self-diagnostic as to how your company is doing on some of these issues that we're talking about. This presentation is going to be recorded, and it'll be available on our website in a couple of days if you'd like to check it out or refer others to it. And the program counts for 1 substantive credit towards the mandatory CPD for requirement for the Law Society of Ontario, for those of you who are lawyers watching the broadcast. So I'm here with our panel today. My name is Brent Arnold. I'm a partner in Gowling's advocacy department, specializing in commercial litigation and also cybersecurity. I'm a breach coach, and I lead some of the firm's cybersecurity and tech initiatives. My co-panelist is Christopher Oates. He's also from our Toronto office and works out of our advertising and product regulatory group with a particular focus on matters related to privacy and electronic commerce. And also joining us is Cindy Koo, who's a business lawyer and works again in our Toronto office on a broad range of corporate, commercial, and regulatory matters, also with a focus on privacy and cybersecurity. So that's your panel. So I'm going to take you through where we're hoping to go today. Oh, I have to start with the usual disclaimer. What you're hearing today is a high-level summary. It's not legal advice and shouldn't be relied on as such. If you've got specific questions, you should be talking to counsel. So here's our very rough agenda. I'm going to talk about some cybersecurity risks that are sort of emergent or heightened in this time. Chris is going to talk about the privacy and regulatory issues associated with the remote work in this COVID environment. And Cindy is going to tell you a bit about what you can do on the front end with your contracts to give you better protection with respect to privacy and data security. So that's the roadmap. So what are the risks that are now particular to, or at least heightened by this remote work environment? Here's what we'll talk about. Existing risks that are now exacerbated by this remote work situation. The intensification of cyber attacks that we're seeing in this sort of new normal. And risks caused by departure from internal controls now that we're all rather hurriedly working remotely, and so is our staff. So the risks that we're facing out of remote work are in some ways very much the risks we were always seeing. But in those days, in the old days, it was mostly your executives and your salespeople, the people on the road you're worried about with this. It's people leaving laptops in places where they shouldn't. It's people losing USB keys with client information, corporate information on it. To some extent, this risk is less now that everyone's stuck in their houses, but you'll remember that period we had where some people were working from home, but the restaurants were still open. If we see a phase in the next few weeks where there is a laxening of social gathering restrictions, but you still have people working from home, this risk is going to increase even more. And anytime you have a scenario where things are leaving the office, this is a risk. One thing that I think it's safe to say has gotten worse with this situation is carelessness around communications. You've got people working from home. Sometimes they've got roommates, they've got family members, other people around them, and they're taking cell and Zoom calls around these people. They've got client documents, either in paper form or on the computer, sitting out where other people can see them. And there's use of video conference platforms without proper controls in place. And they do have these controls to make sure that privacy and data security is optimal as possible. We're seeing risks to do with bring your own device environments, because now for a lot of people, that's exactly what we're facing. Some enterprises were set up to have all of their people working from home. Others, startups, smaller companies, that sort of a thing, or companies that were already working in a bring your own device environment now have employees working from home with those devices. So that creates the problems you would expect. You've got people working on devices that are operating outside of the, out from under the umbrella of the company, the enterprise security. And you've got also problems, around people choosing to use the devices over the devices that they've been given by the company. If using the device given by the company is in some way more cumbersome, you've got people emailing things from their work accounts to their home accounts, people using their home computers instead to do things because they don't like working through the VPN, especially if they're working for the home with slower internet. People find workarounds, and so there's a real danger that people will take that opportunity and the lack of supervision to work in a way that they wouldn't be allowed to work in the office. And these devices, of course, could be operating without any virus protection, without firewalls, without anything protecting logins, that sort of a thing. And again, a risk I think we're going to see more of as we see people going out more, but still not back in the office full time, is unsecure Wi-Fi. Hopefully your employees at home have password protection on their Wi-Fi. Hopefully they're not going in places now where there's a danger that they're working with unsecured Wi-Fi, which is always a problem in restaurants and coffee shops and public libraries, all of this. And some of you have probably heard about this. The description I've heard that I like the most is Wi-Fi pineapples, because they kind of look like pineapples. People going into places that don't actually have Wi-Fi, setting up an account that looks like it belongs to the coffee shop or restaurant or whatever that the person's sitting in. And they're using that, it's essentially a Wi-Fi hub that people sign into unsecured, and they're harvesting their data. So again, a concern we're going to see more of as we see people either being allowed to go out in public or starting to bend the rules around the social distancing as they start to chafe at the restrictions as this situation drags on. We're also seeing in this time, and I know that you'll have heard about this because it's everywhere, a real intensification in cyber attacks. We've seen dramatic increase in the quantity of attacks, the sheer volume, and in the ingenuity of the people taking advantage of the situation. We're seeing hackers exploit essentially employee panic over COVID-19. Everyone's looking for information. Everyone's watching their social media accounts and watching the news minute by minute to see what's going to happen. And they're seeking information when they feel like they're not getting enough information from official sources fast enough. And there's the real danger. You've got also the problem of the lack of sophistication of some of the people working from home. Typically, your executives are used to it. Again, your sales force are used to it. But a big company suddenly now has administrative assistants, other clerical and staff people working from home who never had that option before and possibly haven't been trained for it, certainly maybe haven't developed the sort of habits and discipline around it. And you also deal with perhaps the lack of enterprise controls around people working from home if you're in an environment that wasn't remote at all before and you're not set up for this. So there's the real danger there that you've got people working for the first time in an environment that's largely unsupervised and unprotected. Just to give you a sense of the scope, and there were stats all over the place, but these were some of the ones that jumped out at me. The cybersecurity provider Kaspersky reported a spike in South Africa in daily attacks from 30,000 to 310,000 on March 18th. So a massive increase. 71% of security professionals are reporting an increase in security threats through attacks since the beginning of the outbreak. And interesting to me here, the story of end of 2018 through 2019 was all about ransomware. Ransomware was the most ascendant, most prominent risk. What we're seeing now is a different sort of weighing of those things. We're seeing a lot more phishing attacks, again, taking advantage of people that are looking for information. They're clicking on links, they're clicking on emails. And then from there, you have an increase, well, the development and increase in attacks from sites promising information about the pandemic. And then ransomware actually down towards the low end of that, but still an increase of 19%. So the sheer magnitude of these things is increasing. And what are the kinds of attacks we're seeing? Again, probably the most notorious one that we've seen recently, fake COVID-19 info maps that people click on to sort of figure out where's the virus spreading, how fast, what are the hotspots, kind of a thing, that are actually downloading malware onto the devices. We're seeing a spike in phishing emails as well, often coming from what appear to be legitimate and authoritative sources, the kind of email where you want to be getting information from. There are people posing as World Health Organization, posing as the Center for Disease Control, promising information on COVID, but what they're actually doing is installing malware, or in some cases ransomware. We're also, and this is one of the interesting ones, particularly for those of you who've transitioned from phone call and in-person meeting to video conference, we're starting to see fake conference invites. And think about how many Zoom invitations or other sites you get, services you get in the course of a day that are actually fake. They're very real looking, but they're malicious, and they install malware. And lastly, and this is not your employee's fault if they fall for this, this is more an enterprise risk. We're seeing the exploitation of loopholes, vulnerabilities, gaps in virtual private networks, especially in the situations where companies have sort of had to mobilize VPNs who don't usually use them, get something off the shelf and get it out into running in people's homes in a hurry. So we're seeing enterprise level attacks on VPNs and other remote working software. Finally, and this is one that I think people aren't talking enough, one of the risks that you have is if your internal controls, control over transactions, authorizations for things, if your usual method is somebody walks over to somebody's desk, gets a wet signature, sees the person face to face, or they make a phone call when they get an email instruction, they call the person at their desk, they can see on the display that they're talking to someone at the phone that in the office that's supposed to be the person they're getting authorization from. And that's your method. And these are typical methods of authenticating instructions. None of that's possible now. People are calling each other on cell phones. And you can imagine easily a scenario where somebody gets phished, a hacker gets control of someone's email account, sends an email in their name. So the email address that it's coming from would be the correct address. And the instruction looks like an instruction that would be typical coming from that person. And the method of authentication is call the person. Well, maybe I don't have that person's cell phone number and I'm nervous to ask my boss what their cell phone number is. Or maybe the email says, call me at this number. And it's not the correct person's cell phone, it's the hacker's cell phone. And they say, yes, of course, go ahead with the transaction. So you can see easily situations where the controls that people have in place to make sure that malicious actors don't scam a company start to fall apart because they weren't designed for this remote work environment. I'm going to turn it over now to Christopher Oates, but I just was wondering whether or not at this point, if anyone has any questions for the things we've covered so far, let me know. Otherwise, I think I'm going to, well, actually, I say I have one question. I think I'm going to do what I said at the beginning, and I'm going to hold the questions to the end, but keep them coming, and I'm going to turn this over to Christopher Oates.
Okay, thanks, Brent, and happy to be speaking to you all today. So Brent, in his discussion, discussed a number of increased risks and spikes in attack that we've likely all been seeing in our new working from home situation. So I'm going to speak briefly as to what the breach reporting obligations are if you've actually suffered a breach. One of the repeated themes for me today is going to be the privacy laws still apply, and they apply in the same manner they would have prior to the COVID pandemic, though there may be sort of circumstantial considerations that apply to certain exceptions under them. But from a breach reporting perspective, the first two bullets on the slide, detect you've suffered a breach, is sort of a threshold matter to responding to it. In a number of very prominent breaches that have occurred, the organization was compromised and its information was accessed for an extended period of time before it was even aware of it. The second likewise applies broadly to any organization that suffered a breach, and that's contain it. Despite the fact that the horses may have left the barn, you still need to shut the door and respond to it in that manner. Now, by the time we get to the third bullet, things begin to differentiate depending on who your organization is, what data has been impacted, and what law applies to you. So most of these slides are focused on the federal privacy law, the private sector privacy law, that is the Personal Information Protection and Electronic Documents Act, or PIPA. However, other laws, for example, the province of Alberta has private sector privacy law that includes mandatory breach reporting. The commissioner in Quebec has issued voluntary guidance on it, and sectoral laws may have separate requirements as well. So, for example, many of the health information laws for the health sector have breach reporting. So the first question is, who are you and what law applies to you and what are the obligations under that law? And those may differ from what's on the next few slides. So in evaluating what's happened, it's essential to consider what information was affected. Was the information in fact personal information from a privacy perspective? If it was corporate information, there are obviously very serious implications to that, but that's less of a privacy law question and more sort of corporate governance and risk matter. Is personal information, what was the cause and extent of the breach? How many people were affected? Where are those people? Again, which speaks to the law that applies to you. And what was the circumstances of the breach? Was this a USB key left in a taxi, or was this a malicious scenario where you've suffered theft or loss of data? And lastly, with answers to those three questions, what is the risk of harm that any identifiable individuals may be exposed to? And with that, you'll be able to assess your reporting obligations, as many of the laws we've referred to will include mandatory data breach reporting, for example, to the regulator or to the affected individuals. And lastly, and this will be important for all organizations, is develop a plan to prevent further breaches. So we'll touch a few times on the concept that the law continues to apply, but it does entail a consideration of the current circumstances. And if you've suffered a breach, that's a circumstance that will cause you to assess your preparedness and your responses and plug the hole, so to speak, so that similar scenarios don't occur again. And if we move to the next slide now, we'll discuss what actually triggers the reporting obligations under the federal law. And the answer under PIPA is it's a harm test. The statute requires organizations to consider whether or not the breach they've suffered in the context represents a real risk of significant harm to an individual. And that's a contextual analysis that looks at what information has been affected. So is it non-sensitive information, or is it sensitive information? For example, financial information or health information. And what were the contexts of the breach, leading to a probability whether or not the information will or will not be misused. The phrasing in the statute is significant harm, and there's sort of a laundry list of harms in the statute that obviously fall within it. And if we're talking financial damage or bodily harm, clearly that's triggering the threshold. But one of the learnings we've had, particularly stemming from the case law in Alberta, where there's a similar requirement, is this tends to be interpreted by the regulators as a relatively low bar. So I don't think organizations should be looking at a data breach scenario and just determining that the harm is insignificant in very many cases. Another thing I'd note is this is an area that may differ depending on what sector you're in and what law applies. So this is federal private sector law. For example, some of the health laws have different tests. One of the ones that's interesting is the Ontario Personal Health Information Protection Act, PIPA, which includes among the various categories of reportable breaches a pattern of similar breaches occurring, which may not individually be reportable due to their size, but if there's a pattern of data breaches going on, that becomes reportable. And that concept is important from a risk management perspective under say federal law as well, simply because if you are engaged, if you're experiencing a pattern of low-level breaches, it may indicate systemic issues which need to be addressed before you have a major one. The next slide speaks to who you're obligated to notify under the federal law if you've crossed the significant harm threshold. And the answer is it's tripartite. There's an obligation to go to the affected individuals, the Federal Privacy Commissioner, and lastly, any other organizations or government institutions that may be able to reduce the risk of harm. So that's a contextual consideration. The notice to the individuals and the commissioner are subject to prescribed disclosure requirements in the regulations under the Act, so it's important to consider those in preparing a breach notification. notification to other organizations and institutions would be fact specific. So for example, if you've been a victim of theft or crime, perhaps the RCMP are appropriate for the relevant police force. If financial information has been compromised, perhaps the credit reporting bureaus or the affected financial institutions, that sort of thing. Lastly, on this point, there is an obligation under the federal law to retain records of all breaches you suffer, even in cases where you determine that they don't meet the real risk of significant harm threshold. And those records should contain, again, prescribed information, which includes largely the nature and circumstances of the breach. And this is essentially facilitates commissioner oversight to make sure you are reporting correctly. But from an internal governance perspective, will also allow you to detect patterns of breaches. If there are ongoing breaches that are occurring, the record retention obligation will assist you with detecting those. And with that, I'm going to turn it back over to Brent for some recommendations on hopefully preventing this sort of thing from occurring.
Thanks, Chris. So some of this is common sense, and some of this is going to be for maybe less sophisticated companies an exercise in remedial catch-up. First of all, make sure that employees are aware of and following is key, corporate policies around device use and data security. It's too often the case that we see companies have, for compliance purposes, policies on the books, and the employees are simply not aware of them. New employees start and it's not part of their training. All this is a problem. If you don't have policies in place around this, now's a really good time to start getting those implemented. Just a moment. Also, your incident response plan is key. And if you don't have one, you should be getting one. And that's something that we can help you with. But in a situation like this where you're dealing with heightened risk, it's absolutely crucial. And I would say that companies that find themselves caught up short in this crisis and are the victim of an incident and don't have a plan in place, after the number of months we've had where the guidance has been out there telling people that it's something they need to do, I think they're going to be judged more harshly than they might have been otherwise, because this is exactly the sort of scenario that people have been warning about for years. Make sure, and this is key, and this will be in a lot of circumstances an unanticipated problem, even for companies that have an incident response plan in place, make sure it's something that can actually be implemented remotely. Because for those of you where everyone is now working remotely, often an incident response plan, the first thing is a phone call gets made to a breach coach or an insurer, and everyone gets gathered into a war room, and you set up computer terminals and everyone's ready to work together collaboratively. That's obviously a much greater challenge where your systems have been hacked and now you have to use those systems to coordinate a response to an incident. So if your incident response plan doesn't contemplate the contingency of everyone having to work remotely to address the breach, now is a good time to have that relooked at. You should be reminding your employees at this point, especially the ones who aren't familiar or aren't used to working at home and are perhaps experiencing some early frustration with the systems that are being made available in the remote working environment. Remind them of their cyber risk and data protection training. They're also scared, and this is exactly the sort of environment where they're more likely to be clicking on things they shouldn't because they're trying to figure out what's going on. They're worried about their loved ones and their finances and so on. And if your employees haven't gotten any hard training around cyber risk and data protection, again, this is something you ought to be looking at. And if you're experiencing downtime, maybe now's the time to be looking into getting that training. Monitor your transactions closely. We talked a few minutes ago about the dangers when your internal controls aren't geared to this sort of remote environment. So keep a really close eye on any transactions. And if you've got workarounds in place to deal with the contingency of not being able to get wet signatures and face-to-face approvals of things, make sure that those are still done in a way where you can get proper authentication. I mean, I would suggest, just as a very simple example, you're better off FaceTiming or Zooming or in some other way reaching out to a superior who you can see to have them say, yes, that's all right, go ahead, as opposed to a phone call to a number you don't know sent to you by an email that you think is legitimate but can't really be certain. So make sure that your remote workarounds are capable of making sure that you're still confident that the authentication is real. And with this, I'm going to turn it back to Chris.
Okay, thanks, Brent. So if we move to the next slide, we'll just give a brief overview of some of the privacy law continued applications. All right, Brent, can we advance? Thank you. So I think we won't dwell on this slide because its content should be pretty obvious based on the discussion so far and based on the fact we have a relatively sophisticated audience. So this one may be more useful for, say, employees who are working from home on the first time, for the first time or that sort of thing. So yes, privacy law still applies. Yes, the anti-spam law also continues to apply, and no, there are not COVID-19 specific exceptions that relax their requirements. So there are exceptions built into the law that speak to data sharing that may be appropriate based on an exception, based on a examination of the circumstances in which we find ourselves. But those are contextual and aren't matters that can be assumed. So I think for employees who are working from home for the first time, the message is that while it may feel like it based on these sort of unusual and scary situations, we're not in the Wild West from a regulatory perspective, and nor are we in kind of a post-apocalypse scenario. The law continues to apply, and it'll be important that all of your staff understand that, just so you're continuing to be able to meet your own obligations as a organization, because you remain accountable for the information you possess. Now, as I said, the application of the law is somewhat fact-specific, depending on what provisions of it you're looking at and what information you're collecting and what you're doing with it. But from the perspective of PIPA, the federal private sector law, the core obligation remains that consent is required to collect user disclosed information, and the standards of adequate security haven't relaxed. So that adequate security is something that was discussed in Brent's discussion on data breach or cyber risk prevention, and that's all relevant from a privacy law perspective insofar as it speaks to meeting your obligations to provide adequate security. Now, what are some of the heightened risks we may see in our current situation, or what have we seen people asking us about? And in many cases, there may be data access questions or data collection questions which come up in the normal course and continue to come up. But in the current sort of COVID pandemic scenario, we've seen cases where business partners are requesting employee health information, for example, if they have people visiting on site. And if you're providing that, that is a disclosure of personal information. Likewise, we have organizations that are looking at perhaps collecting more information. So employee or visitor screening, if you have people coming onto your premises, if you're a essential business that is still open, and you may be asking yourself, well, what is the level of, what's the appropriate level for that? And the answer is it's somewhat dependent on the circumstances and the information being collected. There are broad concepts of reasonability and appropriateness, and those are circumstance specific. So it would depend on who the organization is and what data is being collected and what thought is being given to other provisions in the law, for example, data minimization, security, and limiting data retention. So all of those play into the appropriateness of collection and also your overall circumstances as an organization. If you're a frontline healthcare provider, the law that applies is going to be different than the primary ones discussed in this deck, which is the private sector privacy law. But B, the circumstances make it much more pressing, perhaps, to have that information than it would be if all of us are working remotely from home and not at risk of exposing other people to what we've been exposed to. Yeah, another key concern is relaxed or weakened security. So Brent discussed some of the privacy security related issues with everybody transitioning from working from home and using perhaps personal devices for the first time. Another scenario that may arise from that is the inadvertent use of service providers. So for example, if employees are finding workarounds and sending information to their personal devices or programs or applications they may be used to using in a personal capacity but not a professional capacity, then perhaps we're getting into scenarios where you're now having your data processed by a third-party processor where you haven't appropriately vetted their terms of service or the security they're able to provide you. And as an organization with control of data, the federal law has obligations that you use contractual means to ensure the data remains protected when you transfer it to processing. And what those contractual means can look like and some considerations in negotiating contracts or something that'll be looked at by Cindy, our third speaker. And lastly, another one I've seen is we've all received and perhaps sent a flurry of COVID-19 related emails, perhaps from companies we haven't dealt with in many years. And one question I would have is, are we sending commercial messages under the cover of sending out COVID related information? So I think the advice there is to ask yourself what the purpose of the message you're sending is. Is it a true health notice, or are we essentially saying, yes, we're working remotely, our physical office is shut down, but here's how you can still do business with us? And if it's getting into the latter territory, that's a commercial message which would be subject to the anti-spam law and its standard requirements. And again, that law doesn't have sort of specific exceptions allowing you to essentially advertise or send commercial communications under the cover of a pandemic. So there's a few key compliance tips on the next slide. Largely, these are sort of standard privacy type considerations, since, as I said several times, the law continues to apply and doesn't have sort of broad exceptions based on the fact we're in a pandemic. So collection, use, and disclosure under the federal law, federal private sector law requires consent, and there are standards and guidance issued by the commissioner indicating what that consent needs to look like. Broadly, it's focused on the person who's providing the consent rather than what you may understand as a sophisticated business person or lawyer. What does the individual who's targeted by our actions think is happening, and do they understand the nature, purpose, and consequences of what they're agreeing to? Broadly, the federal guidance is that looks at four key considerations: what information is being collected, what's the purpose for that collection, who are you sharing it with if you're sharing it with anybody, and is there any potential risk of harm to the individual as a result? With respect to purposes, it's generally not possible under the federal law to get consent for undisclosed or unduly broad purposes. Consent needs to be informed and understandable. And if you don't understand what people are agreeing to based on your consent language and policies, then certainly no individual will understand it. So I always raise a red flag when discussing privacy language with lawyers or sophisticated business people or marketers, and we're trying to parse a phrase based on comma position or its overall level of comprehensibility. And if you're sort of sophisticated in the market and are having trouble understanding the language that's being proposed, at that point it's probably not meaningful for the average reader, and you can probably just start over. And lastly, I had mentioned this a little bit earlier, but there's important principles of data minimization and limited retention. So generally, it's appropriate to collect only that data you need for the purposes for which you're collecting it, and to retain it for only as long as needed for those purposes, subject to legal or other obligations. Now, on the next slide, we'll look at some of the guidance from the federal commissioner. The Federal Privacy Commissioner has issued guidance on some of the cases where in a number of things I just said don't apply. So cases where personal information may be collected without consent. There's a few similar guidance has been issued by a number of the provincial commissioners, but here we're primarily looking at PIPA with this slide and the following slides. Broadly, probably the most important line in if we flip back, the most important line in the guidance is that the Privacy Commissioner continues to apply PIPA, which continues to apply. So there isn't, as I say, sort of a holiday from legal compliance. A corollary of the fact that the law still applies and the fact that the commissioners are all issuing guidance in recent days is that the various information and privacy commissioners in the Federal Office of the Privacy Commissioner of Canada continue to operate despite the current circumstances. So they haven't closed up shop entirely, though they are working remotely and subject to sort of increased pressures and perhaps delays as a result of the circumstances. So the federal commissioner indicated there may be a delay in their response for organizations that are reaching out to them or ongoing appeals, for example, for access to information and that sort of thing. They haven't indicated, at least in their written guidance, that they're going to be extending timelines or anything like that for organizations who are, say, receiving access to information requests or that sort of thing. The guidance has differed depending on which law you're subject to and which commissioner you're dealing with. For example, the Ontario commissioner has likewise indicated that it may have delayed response times itself, and has also indicated that in applying applying whether or not an institution has been subject to, or essentially has refused to disclose information subject to an access request. Being refusal, in other words, one of the circumstances they consider is the current circumstances that we're faced with. From a federal perspective, I'd note there's generally a 30-day timeline for responding to individuals asking to access their information. However, there is a ability to extend that by 30 days if responding within the initial timeline poses an unreasonable interference on the operation of the organization. Now, generally, that's quite a high test. However, depending on your circumstances, it may be one where if your entire workforce is working remotely and the documents you are asked to access are physical and inaccessible for the time being, it may be one where the context bears on that consideration. And in that context, there is an ability to extend the timeline by a further 30 days, but there is an obligation to provide notice on doing so. So the ordinary statutory considerations that would apply will continue to apply. Another takeaway from the guidance is that the exceptions where information can be disclosed or collected, used, or disclosed without consent are limited. So there aren't open-ended exceptions, just saying, as I said before, we have sort of a holiday on compliance because we're in a pandemic. The law is prescriptive in when information can be disclosed without consent. And it is a contextual analysis as to whether or not a particular set of facts allows you to benefit from it. Another point is that there's a broad concept of reasonability in PIPA. So there's an overarching concept that organizations can only collect, use, and disclose information where a reasonable person would consider it appropriate in the circumstances. And that continues to apply whether or not you're collecting based on consent or you're trying to benefit from an exception to the need for consent. Broadly, you should consider, is the information you're processing necessary to meet the needs and the ends you're trying to achieve by that processing, including the disclosure? Is it likely to meet the need? Is the loss of privacy proportionate to the benefits received? And is there a less invasive means to achieve the same end? This ties back to the data minimization principle we had discussed earlier, where organizations should only be collecting the information they actually need for their. The next slide, we'll look at some of these specific exceptions. And again, I'd note that these are those set out in PIPA, and the guidance provided is that of the federal commissioner rather than the provincial commissioner. So it'll be important to consider what law applies to you rather than trying to rely on exceptions under say PIPA if you're actually subject to PIPA or the law in BC or another privacy law. You need to look at the statute that's applicable in the context. Another thing I'd note is these exceptions are long-standing provisions in PIPA. They're not new in our current situation, but of course the current circumstances are ones which would bear consideration in applying the exceptions. And I'd note that the guidance does tend to provide very clear cases of where it would be likely that these would apply. So don't by any means take these as exceptions to sort of cursorily apply or disclose information without consent. As I say, consent is the standard, and the exceptions are limited and specific. And organizations need to stand ready to demonstrate that they're actually falling within those if they are relying on them. So the first is collection in the interest of the individual, where consent can't be obtained in a timely manner. And this perhaps illustrates that these are limited. The example given by the commissioner is a case where somebody is critically ill, and that would probably be a case where it would be reasonably obvious to most organizations that would be appropriate. And I suspect that on the front line, if one of your colleagues was critically ill or passed out or something like that, there are often, say, emergency contacts or that sort of thing which can be reached out to and perhaps result in a collection of information about that individual, which is then disclosed to, say, a healthcare provider. And that is a collection use of personal information in the commercial context of a corporation, but maybe falling within this exception. And it's probably not something that your staff would think twice about if things are set up appropriately. And the next is legally required disclosures. So these would be cases where a government or law enforcement organization has a lawful authority to require you to disclose information, and the information is for the purposes of enforcing the law of Canada, or a province for that matter. So a pre-pandemic scenario would have been the police either kicking down the door in exigent circumstances or serving you with a warrant and collecting information. And there's what I've always termed safety valves in the privacy law for organizations subject to those kind of obligations. Now, in our current context, a example may be a public health authority requiring disclosure for contact tracing or something like that, if we get to a scenario where those authorities are demanding information and have the legal authority for it. So that may be something which happens down the road, and there are provisions in the privacy law which would account for that. There are two more on the next slide. This is by no means a full breach. The first of these is perhaps the counterpart of legally required disclosure, and this is the previous one would be a compelled disclosure, where you're under a legal obligation to disclose information to the authorities. This is the counterpart where you believe the information is relevant to law enforcement and are choosing to disclose it to the authorities on your discretion. So cases like these historically still today may be cases where you believe there's been a breach of law, you're going to the authorities. Conversely, it may be if there's, say, breaches of quarantine orders or that sort of thing, and you're going to the authorities to disclose information about that. Again, these are all things that will be looked at in the context, but there are exceptions in the law that contemplate these. Lastly, where user disclosure is required to respond to an emergency that threatens life, security, or health of an individual. And this is very similar to the first one, where you're unable to obtain consent in a timely manner in an emergency situation. It is, however, one that illustrates some of the differences between the various privacy laws and the importance of determining what law you're subject to and seeking to apply a law. So many of the privacy laws where you're disclosing information in an emergency scenario require notice to the affected persons. That's not, so the persons whose information you're disclosing, in other words, that's not uniform, however, so it's important to check what exception you're applying to and what requirements apply. There's also some regional variation. An interesting one is that this is, the slide looks at PIPA, and PIPA isn't clear on who is threatened by the emergency situation where you're disclosing information. So, for example, if I was to issue some sort of credible threat to physically harm somebody, and Brent was to report that may well be within the scope of PIPA. The Quebec law, on the other hand, looks at disclosures which disclosure of information where the threat is to the individual whose information is disclosed, rather than more broadly. So it's somewhat narrower, and there may be other provisions in the law which would apply in that context, but it is an important nuance in looking at these disclosures. So again, it's important to consider what law applies to you. And lastly, before I turn it over to, I believe Cindy will be next, organizations need to be cautious of relying on the consent exceptions, and I think we've made that relatively clear over the previous discussions. It's going to be important to be able to demonstrate you're complying, and in doing so, it's important to keep records of what you're doing. So that would include things like what information are you disclosing, who is the recipient, what is the context, and what is the specific legal basis you're relying on for disclosing that information, and what basis are you relying on those exceptions. So, for example, have you received medical guidance that indicates that collection of information without consent is necessary in the context? Have you documented a request from a law or from a government institution, and has it demonstrated its lawful authority to collect the information? And if so, what was that? So really a corporate compliance and record-keeping policy. And with that, I'm going to turn it over to my colleague to discuss some of the considerations in contracts.
All right, thank you, Chris. Hi, everyone. So we'll take a few minutes to run through 5 commercial considerations for your contracts that touch on the sharing of data and information. You might call these tech contracts. I call them tech contracts, but you may call them any other kind of contracts that touch on the sharing of data and information. So could I have the next slide, please? Yes, okay. So the first consideration is who is entering into the contract. Many of you will be in organizations where it's very clear there's a legal department or a specific set of people that triage and filter through triage and filter through where who enters into contracts and all of the processes that you have there for who can sign and for what amounts. That will probably already be in place. But here's a reminder that we've all seen the end user license agreements or the submit forms with a little checkbox that says I've read and accepted all of these terms and conditions. All of those click-throughs are also considered binding. And there's all various terms of use and end user license agreements and privacy policies that deem acceptance as you continue to use them. So earlier, Brent and Chris talked about bring your own device policies. You'll need to be thinking through what's happening on the devices that people bring themselves. What other applications or software have they downloaded that might have various data or information collecting rights in there, and also in terms of even if you've issued devices to all of your personnel, what rights do they have to download new software, even if it's not software that is directly related to your company. So it may be talking about coming back to this idea of deemed acceptance, just using some third party's software to be able to participate in a call or some other activity might be deemed acceptance. So there's a whole universe that may be broader than the universe of contracts that your legal department maybe is thinking of. Next slide, please. So we want to be very clear on, in every contract that you enter into, what information and data is moving between the parties. And I'll just stop for a minute to talk about the distinctions between IP and confidential information and personal information. Every once in a while, we'll see agreements that conflate all of these, and I can understand why, because it's all about sharing of information. But depending on what's actually important in your use case, it'll be important to specify out each of the different layers. So you can see IP as sharing of information that specifically is protected by Canadian intellectual property rights like copyright or patent or trademarks. You can see personal information as being a very specific set of information that includes any factual or subjective information, whether or not it's recorded about an identifiable individual. And both of those are kind of under, you can see them as under the tent, the same tent as confidential information, because you might want to keep all of that private. So just a reminder that what personal information is, and it can be something really obvious like somebody's age or somebody's name, or it can be the combination of different pieces of information that would allow you to identify an individual. For example, if you had my name Cindy and my postal code, maybe I live somewhere super densely populated, and there's a lot of Cindys living in the same postal code. But if I live somewhere very not densely populated and there is only one address on that postal code, then just knowing my first name would be enough to consider that personal information. So just as a reminder, in your confidential information provisions, you want to make sure that any personal information always stays personal information, even if there are certain exceptions that allow for information to not be considered confidential information anymore. Next slide, please. So how do you figure out what data is being collected or used or disclosed? This is a super long list, but I'll start with, maybe we'll just go through, I'll pick a few of my favorite ones. The one that I go to all the time is that first one. Whenever I start a new contract, I ask, what is the flow of information? And it seems very simple. And usually the answer that I get is, oh, well, we do this, and then the app or the software spits out that. And that's what the app does. But that doesn't actually tell us very much about who is sharing what information and where the information comes from. So if you're going through this exercise, it's very helpful, I find, to draw a picture of the, you can call it the life cycle of a piece of information through the contract. Who gets it? Where are the consents? How do they pass it off to somebody else? What does that person do to manipulate it? And then how does it get sent back or shared with the original party or some third party? And if you can sketch out the life cycle of that piece of information as it flows through your contract, then you're in really good shape for a bunch of these other considerations. In light of the time, I'm going to skip to the next slide, please. Thank you. So once you've figured out what information is being shared, you also need to know what obligations apply to the information that is involved in your agreement. So just really quickly, some sources of where those obligations might come from, all of your applicable laws, like Chris talked about, PIPA is a big one, especially when you have personal information. You may have regulatory obligations if your business activity itself is regulated or if you are a regulated entity. You might have corporate policies that go above and beyond the regulatory obligations or applicable laws. And there may also be industry standards that everybody in your industry complies with. And we'll also point out at this point that many commercial contracts live in like a constellation. And so if you change one, if you agree or give up certain rights and obligations in one contract, think about all of the other pieces that connect to that contract. Maybe you have an end user agreement. Maybe you have a privacy policy. Maybe you have a third-party processor for where that information goes. And every time you tweak one piece, you maybe have to think about updating or amending some of your other agreements that go with that to make sure that your protection is seamless. Next slide, please. Another important consideration for your contracts is what obligations will apply in the event of a breach. So the items on this list are generally considerations very common considerations for parties who have their data being processed by somebody else. In a lot of the agreements that we see, it's one party giving data to somebody else that will, and that somebody else will manipulate it or process it or control it for them. But some cases you might need to have these be mutual obligations. So usually we will see an obligation to immediately respond to the breach and to notify you as the giver of information of the breach. There may also be insurance obligations, including an amount specifically setting out cybersecurity risk for a specific amount. There's often an indemnification and defense obligation if somebody else has a breach that causes you to suffer damage due to data loss or privacy loss or breaches under your other contracts, then that's often an obligation that you want to see your service provider provide. And then mitigation, root cause analysis, and resolution. These are often considerations we have when we want the other side to quickly try to fix the problem, do a deep dive investigation to figure out what caused the breach, and make sure that they've taken all the steps necessary to prevent that source of breach from happening again. Okay, last slide, please. All right, so you may all say, Cindy, that's nice, but if I've already entered into the contract, the barn door is already open. So what you can do, though, is you can still pull copies of your contracts, and you might want to consider openly allowing your employees and your contractors and your subcontractors, all your personnel, to proactively disclose what contracts they might have entered into through downloading or on their personal devices or through use. And so then you can really understand what universe of contracts you're looking at. Then you've got to review your contract terms. Can you live with the terms? Are there some that you might have to try to amend or terminate or not? Or otherwise, can you figure out where your risk is and then only use a specific technology for a very low risk use and instruct your personnel to do so that you can still continue to have the benefits of the technology, but maybe not for your super sensitive information. So considering all that, you might want to think about what policies, like your bring your own device policy or your remote work policies that might need to be updated, and maybe some controls about who can download or click through or accept or otherwise bind your organization to contracts. All right.
Thanks a lot, Cindy. And thank you, Chris. We're coming up close to the end, and I think we're going to cherry pick a couple of questions that we think we can answer in a short term. But before we do that, because you all went to all the trouble of answering the poll questions, I would like to scroll through the poll questions just so you can see where you are vis-a-vis your fellow guests. And I can tell you we have people here from a range of very sophisticated and big companies. So that's the cohort that you're in. So if I can ask our invisible moderator to bring up those poll answers, let's take a look. All right, just give me 1 second, folks. All right. Well, it looks like we may not have that available, unfortunately, but if anyone's curious, they can always reach out to us, and I'm happy to tell you where things ended up. In the meantime, maybe we'll take a minute and go to the Q&A and grab some of the questions that we think we can answer quickly for you.
Okay, so I think I'll take the mic for a few of the questions. As we said, we're running a little bit short of time, but if anybody would like to reach out by email, we'd be happy to pick some of these up offline. So the first one is, some of these are fact specific, so we'll discuss them a little bit in general terms, but regarding frontline services requesting for employee information, screening, temperature, for example, and whether this is a violation of the employee's privacy and if you need to take added precautions because we have that personal information. There's a fair bit to unpack here, but perhaps we'll just back it up from the end of the question to the beginning. So do you need to take added precautions? I think that's probably a yes. Generally, the obligations under privacy laws are keyed on the sensitivity of the information you have. Health information is more sensitive than non-health information. So if you've expanded your collection, then I think increased precautions would be appropriate. Now, I referenced PIPA in that sentence, but of course this gets us into where the law is more complicated, because depending on the nature of the organization, that may or may not be the appropriate law. Broadly, PIPA would apply to employee information in the context of federal works or undertakings, as opposed to provincially regulated private sector employees, which may or may not be subject to employment laws that cover personal information in the employment context, depending on where they're located. So Alberta, BC, and Quebec have provincial laws that apply to the area, and they have different requirements than the federal law. Whereas if you're a federal worker undertaking, then the federal law we've been discussing in this slide will apply. More broadly, I think the considerations and even asking for collecting that data would be ones we had discussed in the slide, or in the slide deck. And that's the broad questions of proportionality, consent, and reasonableness. So is this information necessary to meet the purpose, presumably, of preventing health, preventing compromising the health of your other employees or customers or patients, depending on the line of business? And that would depend on who you are. The answer may differ for different organizations. So for example, if you're a long-term care home or something like that, then A, PIPA wouldn't be the applicable law, but B, you're defending a vulnerable population. That's a different consideration than if you're operating a drive-through or something like that. So it's a very contextual analysis, and would really be worth looking at sort of who you are and if you can actually justify that collection. And if there are other collections that would perhaps meet your purposes without collecting sensitive data. So that could be things like questioning people as to if they've experienced health symptoms that would be typical of COVID, and perhaps not recording that information. So again, applying the principles of data minimization and proportionality. There's also a question about productivity monitoring software. So I think a lot of what I had just said for the previous question would be applicable for that one as well. Broadly, organizations need to be A, considering what law actually applies, and B, whether what they're doing is proportionate to meet their ends, and they can justify the impact on the person's privacy. For monitoring software, again, there's a fair amount of subtlety based on what law applies and whether it applies in the employment context. But I would call out that from a PIPA perspective, we had discussed the reasonableness principle and the idea that information collection needs to be reasonable in the circumstances, consent aside. And the commissioners issued inappropriate data practice guidelines, and one of the things that was considered unduly invasive would be monitoring somebody using their own device. But again, I'd caution it is a factual specific manner, and you need to look at the information collected and the purposes for which it's being collected in the overall context in determining appropriateness. And I suspect that's all we have time for. But as I said, if anybody would like to reach out by email, we'd be pleased to hear from you.
Terrific. Thanks very much. There was one other question I'll address briefly. Somebody mentioned that they're at a firm where they're being asked to take specifically Zoom off of their devices, and is there a way that they can still access the content? This and other talks, as we do them, will be posted to the website, and you can just view them at your leisure as regular video feed. And we invite you to check out the collection as well as the COVID portal, where we've been aggregating all kinds of resources to help our clients through this difficult time. Thanks to the panel, and thanks for all of you for joining us. And we'd love to hear feedback. And as we said, feel free to reach out to us. You'll get the slide deck shortly, and you can see our contact there. Thanks, everyone, and have a great day.